Hong Kong Crypto Regulatory Series. Regulation of Virtual Asset Portfolio Managers. Firms managing virtual asset portfolios, whether as licensed asset managers, or as licensed securities dealers, will be subject to additional licensing conditions. These apply firstly to firms, which are or are to be licensed, as asset managers, because they manage portfolios of traditional securities, or futures contracts, and which also manage, or plan to manage portfolios investing solely, or partially in virtual assets. This is subject to a de minimis provision, although the Regulatory Framework Statement, and the Regulatory Standards for Licensed Corporations Managing Virtual Asset Portfolios, Regulatory Standards, at Appendix 2 of the Regulatory Framework Statement, are inconsistent as to how the de minimis provision will apply. According to the Regulatory Framework Statement, a virtual asset portfolio manager will only be subject to the licensing conditions if it intends to invest 10% or more of the gross asset value of the portfolios under its management in virtual assets, i.e., irrespective of the makeup of individual portfolios. According to the regulatory standards, however, the licensing conditions will be imposed on licensed corporations, which manage or plan to manage portfolios with 1. A stated investment objective to invest in virtual assets, or 2. An intention to invest 10% or more of the gross asset value of the portfolio in virtual assets. This suggests that a single managed portfolio, investing more than 10% of gross asset value in virtual assets, would subject the portfolio manager to the additional licensing conditions, even if the portfolio manager's investment in virtual assets amounts to less than 10% of the gross asset value of all portfolios under its management. The new licensing conditions will also apply to firms which only manage funds which invest solely in non-SF virtual assets. These firms are not required to be licensed as asset managers, since the management of a fund, which does not invest in securities or real estate, is outside the definition of asset management. However, a firm that distributes such a fund in Hong Kong is required to be licensed as a securities dealer, and the SFC will impose the new licensing conditions for virtual asset fund management on its securities dealer license. The licensing conditions will not, however, apply to 1. Licensed corporations, which only manage funds investing in virtual asset funds, i.e., funds of funds. Or 2. Licensed corporations which manage portfolios whose mandate is to invest mainly in securities and/or futures contracts, where the investment in virtual assets exceeds 10% of NAV as a result of an increase in the prices of the virtual assets held in one or more of the portfolios. The licensed corporation is required to take all reasonable steps to reduce the portfolio's investment in virtual assets below the 10% of gross asset value threshold. If, however, the position is expected to continue, i.e., virtual assets will continue to exceed 10% of gross asset value, the licensed corporation must alert the SFC, which will consider imposing licensing conditions. Failure to notify the SFC may result in disciplinary action. Failure to notify the SFC may result in disciplinary action, bringing virtual asset portfolio managers within the regulatory net. All existing licensed corporations and license applicants are required to notify the SFC if they currently manage or plan to manage one or more portfolios that invest in virtual assets, or intend to hold non-SF virtual assets on behalf of the portfolios under their management. The notification requirement applies even if a. The intention is to invest less than 10% of the portfolio's gross assets in virtual assets. Or, b. The virtual assets involved are securities, or futures contracts. Failure to inform the SFC may constitute a breach of the Securities and Futures Licensing and Registration Information Rules. The licensing process. On being informed that a firm is managing, or plans to manage virtual asset portfolios, the SFC will send the standard licensing conditions to the firm, and these may be varied following discussions with the firm, according to its particular business model. Existing licensed corporations, which do not agree to comply with the licensing conditions, will be prohibited from managing virtual asset portfolios, and must unwind their virtual asset positions. A new license applicant will have to agree to the licensing conditions proposed, or its licensing application will be rejected. The licensing conditions. 1. Restriction to professional investors and disclosure requirements. Only professional investors, as defined under the SFO, are allowed to invest in a portfolio with a stated investment objective of investing in virtual assets, or b. an intent to invest 10% or more of the portfolio's GAV in virtual assets. This restriction does not apply to funds authorized by the SFC for retail distribution under Section 104 Securities and Futures Ordinance. As discussed, in relation to licensing trading platforms, portfolio managers may not wish to be restricted to dealing only with professional investors. Despite the restriction to professional investors, firms will be required to disclose all associated risks to potential investors and distributors appointed for the distribution of virtual asset funds. Two. Safeguarding of assets. Licensed corporations will be subject to requirements to ensure the safe custody of virtual assets. Although the SFC acknowledges that virtual asset funds face a unique challenge due to the limited availability of qualified custodian solutions, the SFC is imposing onerous obligations on licensed corporations with regard to their selection of appropriate custodians. Their ability to comply with these requirements will depend on the willingness of custodians to disclose information on their financial resources, corporate governance and risk management, etc. A. Assess and select the most appropriate custodial arrangement, for example, whether to hold the assets itself, or with a third-party custodian, or an exchange, taking into consideration the advantages and disadvantages of holding virtual assets at different host locations, by way of hot wallets, cold wallets, and deep cold wallets, with regard to, among others, 1. The ease of accessibility to virtual assets, i.e. time required to transfer virtual assets to the trading venue. And 2. The security of the custodial facility, i.e. whether appropriate safeguards are in place to protect against external threats, such as cyber attacks, and b. Exercise due skill, care and diligence in selecting, appointing and conducting ongoing monitoring of custodians, by reference to factors, such as the custodian's 1. Experience and track record in providing custodial services for virtual assets, 2. Regulatory status, particularly whether its virtual asset custodial business is subject to regulatory oversight, 3. Corporate governance structure, and the background of its senior management, 4. Financial resources and insurance cover for compensating customers for loss of customer assets. And 5. Operational capabilities and arrangements, for example, its wallet arrangements and cybersecurity risk management measures. Where virtual assets are held by the licensed corporation itself, the licensed corporation is additionally required to a. Document the reasons for self-custody. B. Implement appropriate measures to protect the assets. C. Ensure the effective segregation of the virtual assets from the licensed corporation's own assets on its insolvency. D. Use best endeavors to acquire and maintain insurance cover over the virtual assets. And E. Disclose the risks of self-custody to investors. Three. Portfolio valuation. The SFC recognizes that there are currently no generally accepted valuation principles for virtual assets, particularly ICO tokens. The licensing conditions will, however, require licensed corporations to select valuation principles, methodologies, models and policies, which are reasonably appropriate in the circumstances, and in the best interests of investors. These will also need to be disclosed to investors. Four. Risk management. Licensed corporations will be required to set appropriate limits for each product and market the portfolios invest in, and each counterparty to which the portfolios have exposure. They should, for example, consider setting a cap on portfolios' investment in illiquid virtual assets and newly launched ICO tokens. Periodic stress testing should be carried out to assess the effect of abnormal and significant changes in market conditions on portfolios. Before transacting with virtual asset exchanges, licensed corporations will be required to assess the reliability and integrity of the virtual asset exchange, taking into account matters such as the virtual asset exchange's A. experience and track record, B. legal or regulatory status, if any, C. corporate governance structure and background of its senior management, D. operational capabilities, E. mechanisms, for example, surveillance systems, implemented to guard against fraud and manipulation, with respect to products traded on the exchange, F. cybersecurity risk management measures, and G. financial resources and insurance cover. Exposure to individual virtual asset exchanges should be limited by setting appropriate caps. Five. Auditors. The SFC notes that the accounting profession has no agreed standards and practices for how an auditor can perform assurance procedures to obtain sufficient audit evidence for the existence and ownership of virtual assets, and ascertain the reasonableness of the valuations. Despite this, the SFC will require the appointment of an independent auditor to audit the financial statements of managed funds. Despite the difficulties acknowledged by the SFC, it will require licensed corporations to consider auditors' experience and capability in checking the existence and ownership of virtual assets, and ascertaining the reasonableness of their valuation, in their selection of an auditor. Six. Liquid capital. A licensed corporation which holds non-SF virtual assets for portfolios under its management, will need to maintain a required liquid capital of at least 3 million Hong Kong dollars, or its variable required liquid capital, whichever is higher. Further lectures cover the current Hong Kong regulatory framework for virtual assets.